Hi, and welcome to the latest webinar in the Premises Liability series presented by Seacrest Wardle. My name is Samantha Orvis, and I'm a partner in the firm's Troy office. Today, we'll be talking about special considerations for landlords. Several of the other webinar topics that we've already discussed and will discuss in the future will delve into greater detail and some of the issues mentioned here, so be sure to check those out as well. In any premises claim, the big question is who is in possession and control of the premises at the time that the loss occurred. Property owners can still be held liable even if another entity has possession and control, but it's a separate duty owed to the plaintiff. When it comes to this, there are a few nuances to consider, such as berm areas. That grassy area between a sidewalk and the street, and that can be an area that the landlord does not owe a duty to maintain if a municipality or city has an easement over that area. When it comes to driveway approaches, the same rule applies. A landlord's legal obligations when it comes to premises liability are governed by the Landlord-Tenant Act, MCL 554139. Generally speaking, a landlord has the duties listed here on this slide. They must keep the premises and common areas fit for their intended use, keep the premises in reasonable repair, and comply with state and local laws pertaining to health and safety. Common areas would be considered those areas in an apartment complex where everyone has access. Those are typically maintained by the landlord or someone the landlord has hired to do this job. Now we are going to briefly discuss open and obvious, but this topic itself was a subject of an earlier webinar presented by my partner Mark Masters, so in an effort not to be redundant, we won't discuss it at length today. The open and obvious defense, even historically, could not be used to avoid a specific statutory duty. It would not apply to cases where an injured party was claiming a breach of a statutory duty, such as those we just discussed in the Landlord-Tenant Act. The duties to keep premises in reasonable repair, keep premises fit for intended use, and the obligation to follow state and local laws. There are, however, some exceptions to a landlord's statutory duties. Those include the social guest exception, fixtures exception, and notice exception. You might be wondering, what exactly does that mean? Well, the landlord's statutory duties do not extend to social guests. For example, if someone visiting or staying in an apartment makes complaint about a broken step or a stair to a property manager, as they did in the case of Walker v. Gila Management, LLC, an unpublished opinion from the Michigan Court of Appeals issued back in July 2021, and that person was subsequently injured because of some sort of disrepair that they alleged, they could not bring a claim that the landlord violated the Landlord-Tenant Act. This is because the landlord owed them no statutory duty, and therefore could not be found to violate a duty to someone who is not a tenant or a party to the lease. As far as fixtures are concerned, generally, a landlord does not owe statutory duties as it relates to fixtures on the property. You might be asking yourself, well, what's a fixture? Fixtures are things installed or otherwise affixed inside a building or on the land. They're generally to become part of the land or the building, such as cabinets, heating systems, wall-mounted ovens. They're generally not intended to be removed. Lastly, the notice exception is probably the one we see the most often in premises liability cases. An injured party must be able to prove that a landlord had notice of an alleged defect in order for statutory duties to apply at all. This is especially relevant to snow and ice cases in Michigan. We're going to circle back to the open obvious defense as this relates to the notice exception. Open and obvious as a defense has evolved recently. Once upon a time, snow and or ice on the ground was considered so open and obvious that there was generally not a duty owed by any landowner to an invitee as it pertained to these types of conditions on land. Defense practitioners like myself and my esteemed colleagues here at Seacrest Wardle would raise this defense and predictably achieve summary disposition on most of these claims. With the evolution of open and obvious, the analysis now considers whether a landowner breached a duty that was owed. If the claim arises out of a hazard that is considered a natural accumulation of ice and or snow, then the landlord has a duty to take reasonable measures within a reasonable amount of time to diminish the hazard for practical purposes. Which means, did they go out and shovel and salt, or was someone hired to perform that service within a reasonable amount of time? Much to our dismay, as defense attorneys, open and obvious no longer bars recovery of damages, and the analysis now shifts consideration to whether an injured party bears some responsibility. Do they share comparative fault in confronting what would otherwise be considered an open and obvious condition? We used to analyze whether or not there were any special aspects that existed. Well, that consideration is no more. A landlord also has no duty to guarantee that there is never ice or snow on the premises, but only to provide a means of reasonable ingress and egress. You might recall earlier in the discussion that the landlord's duties under the Landlord-Tenant Act were to keep the premises and common areas fit for intended use, in reasonable repair, and comply, of course, with local and state laws. There are certain rules that apply to snow and ice removal in a landlord's statutory duties. For example, parking lots and sidewalks are considered common areas, and accumulation of snow and ice in these areas can render the premises unfit for intended use, such as walking, meaning the landlord has a duty under the Landlord-Tenant Act at MCL 554.139 subsection 1A. However, accumulation of ice and snow does not constitute a defect in property, and therefore the landlord does not have a duty under section 1B unless it caused damage to the property. Something to consider here. There's an unpublished Court of Appeals case involving a slip and fall on snow and ice. This is under the case True Blood v. P&G Apartments from 2019. And this discussed the separate and distinct duties owed under the Landlord-Tenant Act. This case and the court in that case, strike that. The court in that case held that the duty to comply with health and safety laws is distinct from the duty to make reasonable repairs, even though both are set forth in the Landlord-Tenant Act at MCL 554.139(1) sub B. So even though the duty of reasonable repair did not apply to common areas like sidewalks, it left open questions about whether the other duty at the same subsection could still apply in these circumstances involving snow and ice, which is the duty to comply with health and safety laws. Also, keep in mind that as a landlord, you can shift the duty of snow and ice removal to tenants in a standalone home if the lease agreement states as much. Let's consider further the difference between various places someone might be traversing in a slip and fall case. If the question is whether or not the area is fit for the intended use under the Landlord-Tenant Act, strike that. If the question is whether or not the area is fit for the intended use under the Landlord-Tenant Act, then we must understand what the intended use is for each part of the land. As you'll see on the slide here, sidewalks are intended for pedestrian use. Driveways are intended for both pedestrian use and for parking vehicles. Parking lots are intended for parking vehicles and pedestrian access to those vehicles. So this is going to be a part of the analysis, and the court's analysis when taking up whether or not there was a violation of any statutory duty by the landlord. Keep in mind that driveways and parking lots are not the same thing. This is going to be a very case-specific. Sometimes driveways grant access to garages or residential units and are considered more like sidewalks than parking lots. Recall that sidewalks are intended for pedestrian use and parking lots are intended for parking vehicles and pedestrian access to those vehicles. There would have to be some evidence that the intended use of the driveway was for pedestrian traffic. There are a couple cases relevant to this discussion, that being Hendricks v. Lautrec Ltd. and Duff v. v.J. Wellington Enterprises, Inc. Hendricks dates back to October 2016 and is unpublished opinion of the Court of Appeals. In that case, the plaintiff alleged that ice on the driveway caused from a path of runoff from a downspout was a dangerous condition, rendering the driveway unfit for pedestrian use. The plaintiff brought a common law premises liability claim and also a claim under the Landlord-Tenant Act for failure to keep the common area fit for intended use by the parties. The trial court in that case granted summary disposition for the defendant, landlord, on both claims. On appeal, the court reversed the dismissal of the plaintiff's statutory claim and remanded, holding that the ice created a dangerous condition, making the driveway unfit for pedestrian use. It noted that the driveway is not a parking lot and is more akin to a sidewalk, which is intended for use of, you got it, pedestrians. However, Duff v.J. Wellington, another unpublished case coming out of the Court of Appeals, strike that. However, Duff v.J. Wellington Enterprises, another unpublished case coming out of the Court of Appeals just about a year later in 2017, was at odds with this. In that case, the plaintiff was injured in a slip and fall on black ice while walking on an asphalt driveway at a campground. He both lived and worked at the campground. The plaintiff sued the campground owner, claiming negligence under a premises liability theory and for violation of statutory duties to keep common areas fit for intended use. The trial court granted summary disposition for the defendant, finding the condition was open and obvious, but also that the area where the plaintiff slipped and fell was fit for its intended use as a roadway. The court found that the primary intended use of the driveway was to accommodate vehicular traffic, and there was no evidence that the roadway was unfit for vehicle use or accessing vehicles. The Court of Appeals agreed, making this somewhat at odds with the earlier opinion issued in Hendricks. You'll recall that a landlord has a duty to provide reasonable access to parking spots in a parking lot. And this relates to our earlier discussion on providing a clear means of ingress and egress. You should note that there is no higher duty owed to handicapped individuals and their ability to access handicapped spots. The duty is still to provide reasonable access. Also, you'll note the court's unpublished opinion in Amin v. Village Park Preservation, another case coming out of the Court of Appeals in March 2020, that any snow and ice accumulating between parked vehicles does not render a parking lot unfit for its intended use. In that case, the snow had been cleared off of the sidewalks in the parking lot, but there was still snow between the parked vehicles. Now I'd like to talk about a hodgepodge of other types of defects that might be claimed. The first being pests or bugs, such as bed bugs. We see some of those cases. There's generally no duty under the Landlord-Tenant Act that governs spiders, bed bugs, etc. A tenant has a duty to maintain cleanliness of parts of the premises that they occupy and control pursuant to MCL 125.474. Now let's talk about dogs. What about pit bulls? What about other dogs with known dangerous propensities? A landlord can only be liable if the landlord has actual knowledge of dangerous propensities of the dog and still lease the premises to the dog owner. And this is true even where a lease has language setting forth rules and regulations pertaining to keeping pets on the premises. I understand that criminal activity was recently addressed in a recent webinar by my partner, John Weston, so I will be very brief on this topic. As stated in the slide, a landowner only owes a duty to tenants and their guests to take reasonable measures in response to an ongoing crime that takes place on the premises in the landlord's control. What does that mean? Basically, you have to call the police if made aware. It's important to be aware, however, that the Landlord-Tenant Act, which is much of what we discussed today, does not apply to condominium owners or co-owners. There are separate laws which govern under the Condominium Act. However, the Michigan Supreme Court recently ruled that condo associations owe a duty of care to co-owners under premises liability theories. This was taken up in a recent opinion issued in 2024 in Giannini v. London Townhouses Condominium Association. Although condo associations do not owe a duty under the Landlord-Tenant Act as to common areas, the Condominium Act found at MCL 559.101, does not preclude a co-owner's common law premises liability claim. Co-owners are considered invitees of the association and can maintain an action against the association now. They are no longer limited to breach of contract and injunctive relief lawsuits against condo associations. As we wrap up here, I want to touch on Truth in Renting. Truth in Renting Act as it pertains to residential leases specifically. MCL 554.633 contains a provision that a rental agreement cannot waive or alter a remedy otherwise available to the parties when premises are in such a condition that violates covenants of fitness and habitability required pursuant to the Landlord-Tenant Act. Such a provision would basically exculpate the lessor from liability for failure to perform or for negligent performance of duties imposed by law, and this is not allowed. It's considered void as against public policy. And lastly, look, when it comes to commercial leases, you can do whatever you want. You can put pretty much whatever you want in a lease, including language governing who will be liable, who's going to indemnify or defend in the event of a loss, who has possession and control, who's responsible for what, and also you can ask that the landlord be identified as an additional insured under the tenant's policy in the event of a loss or a claim arising out of or sounding in premises liability. I want to thank you for attending this webinar on special considerations for landlords. Again, my name is Samantha Orvis, and I'm a partner in the Troy office.